1919 was an auspicious year in history. The First World War ended, ushering a drastic change in the world order. The Philippine Islands had been a U.S. territory for 2 decades and was promised independence under the Jones Law of 1916. Progressive reformers saw the country and its people as a major target for modernization, and education was its main weapon. 7 forward-looking Filipinas came together in 1919 to create a school where young women could gain the knowledge and skills that would make them modern women. Paz Marquez Benitez was the first president of the Philippine Women's College. Jose Abad Santos was its first chairman of the Board of Trustees. Francisca Tirona Benitez was the second president, and with her husband Dean Conrado, guided the school from a house on A. Flores Street to its iconic Taft Avenue campus. In 1932, the college became a university, making PWU the first university for women in Asia founded by Asians. It provided a space where innovations in education flourished, and young people were encouraged to be the best that they could be. For over 100 years, the Philippine Women's University has been known as a leader in quality education. In 1934, PWU moved into its main campus on Taft Avenue, and since the 1970s has been co-educational. Located in the heart of Metro Manila, it is easily accessible by public transport and surrounded by affordable housing. Today's PWU offers undergraduate and graduate courses in several fields of study. Its business and management programs are responsive to the needs of industry, using evolving technology for global competence. PWU graduates excel in arts and sciences, education, social work, and diplomacy. Its fine arts and music programs have produced outstanding graduates through a holistic education that treasures heritage as well as excellence. PWU has pioneered in fields such as food science, nutrition and dietetics, medical technology, pharmacy, and nursing. PWU continues to play an essential role in producing graduates who possess the skills that make them competitive in the country and anywhere in the world.
Hanggat may isang nagugutom, hanggat may isang nauuhaw, hanggat mayroong mga pusong nagdurusa, namamanglaw, hanggat mayroong naaalipin, sa layo ay nanunulong. pandamdamin, naghahagilap ng tugon. Tayo ay mayroong gawain, tayo ay mayroong misyon. Hanggang ang kanyang katarungan, pagpapalahat ng mahal, mangyari sa sandaigdigan, ang pangalan ay itahal. Hanggang ang iyong kapahiling, hanggang may pagkakataon, tayo ay mayroong gawain, tayo ay mayroong misyon.
A pleasant afternoon to all our participants. I'm Eileen Valderas, a third-year social work student.
And I'm Azinaya Umpok, also a third-year social work student. And we are your hosts today.
On this webinar series number 1, entitled Child Custody Amidst COVID-19 Pandemic, with the theme, Maintaining a Healthy Family Environment, Upholding the Best Interests of Every Child.
Ate Mai, can you share a little background on how we come up with our topic?
Of course, I think we came up with our topic because we are very curious and interested in child custody cases. We want to know the different practices applied during this pandemic and what are the coping strategies they have used to overcome these challenges.
I agree, Ate. Also, we want to spread new and relevant information regarding child custody while we are still in the middle of this pandemic. Because as we all know, the problems that every family within our society face will not stop just because we are dealing with the pandemic. Actually, the rate of the cases regarding child custody might be increasing right now. So I am confident that our participants are also interested and excited to learn a lot today from our topic and through our resource speaker.
But before we proceed, we would like to remind our participants to make sure that you have a stable internet connection to avoid missing important topics of the webinar. Please mute your microphone while the presentation is ongoing. The participants will have a chance to engage themselves in the discussion. There is a time allotted for an open forum after the presentation of the speaker. You may take from the speaker. And we would like to know your feedback by filling up the evaluation survey after the program.
To officially begin our program, may I request everyone a moment of silence for our invocation to be followed with the Philippine National Anthem.
Wonderful, the Lord God made
dagat at bundok, sa simoy at sa langit mong bakaw. May dilagang tula at awit sa paglayang minamahal. Ang kisap ng watawat mo'y tagumpay na nagdidigdig. Ang bituin at araw niya kailan pa may di magdidinig. Lupa ng araw ng wal at ipagsintabay langit sa piling mo. Aming ligaya dapat may mga aming ang mamatay ng dahil sa'yo.
Hello once again. To set the mood of our program, I would like to give the virtual floor to my co-host, Ms. Azinayong Pok, for the acknowledgement of the participants today.
Of course, we would like to acknowledge the presence of our Dean of the Philippine School of Social Work, Ms. Evelyn Valencia, together with our professor, Ms. Cecilia Cabile, and the Philippine School of Social Work faculty and staff, Ms. Maricel Condino, our social worker for Unicorp, Ms. Gina Manabat, and to all our participants today. Moving on with our participants, the PWU Unicorp Partner Community from Barangay 54 Pasay City, Ms. Cecilia Villanino, and Ms. Mary Jane Echate. Next is from Barangay 694 Manila City, Honorable Chairwoman Margaret Reyna, our BSS alumni and current students from social work and other college departments. Also, we have social work practitioners and other professionals joining us today. And now, for the school participants from the Ateneo de Davao University BSSW students, Zamboanga Peninsula Polytechnic State University, Cebu Technological University Danao Campus, Occidental Mindoro State College, Nueva Ecija University of Science and Technology, St. Peter's College, Southern Christian College, St. Louis University BSSW students, and to all our participants and viewers in our Facebook and YouTube Live, welcome. We are glad to have you today with us, and we hope that you will join us until the end of our activity. Now, allow me to give the virtual floor to our ever-supportive and hardworking Dean and Program Chair of the Philippine School of Social Work, Ms. Evelyn B. Valencia, for her opening remarks.
Thank you, Essie. Thank you, Mylene. Wow, this is a very great opportunity for all of us. A pleasant afternoon to everyone. It is my pleasure to invite all of you to the series of webinars organized by Ms. Cabile's class, Seminar on Current Trends and Social Work Practice. So allow me to say thank you to Ms. Cabile and to all the students of this class. Thank you, Ma'am Cecil. This is the first webinar out of 4 webinars organized by our students. And it is a great pride and honor that we were able to invite our resource speaker for today, who willingly agreed to share his knowledge and expertise about children's protection. And this afternoon, he will specifically discuss child custody amidst COVID-19 pandemic. Thank you, Attorney Boyet, our friend, matagal na namin kaibigan yan, for gracing our invitation despite the short notice and your busy schedule. As mentioned earlier, this topic is really of interest to our future social workers, and this will help them in their future careers as social workers. Also, we have invited social workers from our partner agencies and communities, and I am sure they will be able to apply the learnings from this webinar to the cases that they are handling. Children, as we know, they are vulnerable sectors in our society, especially now in this pandemic situation. And I think they should still be given utmost importance. Baka kasi nakakalimutan na din because all are busy working from home and all are busy addressing COVID-19. That's why we are actually hearing concerns and issues about children. And maybe one of the issues and concern ay yung this can be actually attributed to children's custody. So our resource speaker will highlight this um, topic a little later. With this, I am happy to welcome our student participants from different schools, along with their deans and department heads, the social workers and staff of our partner agencies, our community partners, our students and faculty of PWU. Good afternoon and welcome to this first webinar series, Child Custody Amidst COVID-19 Pandemic. Mapagpalang hapon sa inyong lahat. Good afternoon.
Thank you, Ms. Evelyn, for the wonderful and motivational speech for all the participants and viewers today. To proceed, it is my great honor to introduce our speaker for today's webinar. Our speaker is a graduate of Bachelor of Arts degree, major in philosophy from Ateneo de Manila University, and a Mulri awardee for literary excellence. He also obtained in the same reputable university his Juris Doctor degree. He has served in numerous occasions as legal consultant and civil servant capacity in the following government agencies, such as PAGCOR, MTRCB, MWSS, Department of Justice, Office of the Ombudsman, Department of Social Welfare and Development, Council for the Welfare of Children, Department of Education, Inter-Country Adoption Board, House of Representatives, Senate of the Philippines, Office of the Vice President, and Office of the President of the Philippines. Currently, he is serving as a legal counsel of the Office of the City Mayor, Local Government of Quezon City. Our resource person has vast experience of social civic involvements in the following agencies: public service program of local radio stations such as DYME Masbate 738, DZRB 738, and DZMM, Puntong Legal program with radio anchor Marichelle Yao. Tulong Dunong Foundation Incorporated, Alay Kalingang Legal Pambata or Akibat, Bantay Bata 163, ABS-CBN Foundation Incorporated, Kaeskwela, Association of Child Caring Agencies of the Philippines, and Child Justice League Incorporated. More so, he has been able to serve in the private firms and non-government organizations, both in local and international, such as Alliance of Filipino Workers, Katarungan sa Kababaihan at Kabataan, United States Agency of Development, UNICEF, Winnay's Holding Philippines Incorporated, Huckleberry Interactive Technologies, Alaska Milk Corporation, and Aceron, Vehemente, Avila, and Del Prado Law Office. Apart from these professional credentials and career affiliations and accomplishments, our resource person is also passionate and has knack for literature. He has published some literary books, articles, and recently published a book timely for the pandemic period that discusses about practical guidelines that provide guidelines on debts, rents, and other matters affected by the pandemic and quarantine measures. This book is entitled Time Out Muna, Gabay sa Utang at Iba Pa sa Panahon ng Pandemya, published by Anselmo Press 2020. So friends, guest participants, it is my honor to introduce to you our resource person for today, and let us warmly welcome a prolific, humble, and seasoned child advocate, Attorney Noel R. Del Prado.
Thank you, Ms. Mylene. Thank you, Dean Eve, Ms. Maricel, Ms. Naya, and the whole PWU community, and all the other universities and schools that are participating remotely. So let me start by sharing my screen. So when I was invited by Dean Eve and Miss Maricel, I did not hesitate because aside from being my friends, they are my bosses and leaders in their own right, not because of their positions, but because of their dedication to the field of child protection in the Philippines. So I consider them as leaders, my leaders, and so wherever they go, I go with them. So when we talk about the topic of custody of minors, we are talking about not just children who are in the care of their families, their mothers and fathers, or mothers or fathers. We are also talking about the multitude of children who are abandoned, orphaned, and those who have lost both parents by, this is the latest, I think, of the UNICEF statistics, 2019. We have all over the world 153 million abandoned children. Out of that, they are constituting also 140 million orphan children. And within the 140 million orphan children all over the world, there are about 15 million who have lost both parents. Out of the 150 million abandoned children worldwide, how many abandoned children do we have in the Philippines? We have around, again, same time, 2000, as of 2018, we have a total of 1.8 million abandoned children in the Philippines. Okay. When we talk about abandoned children, when we talk about orphan children, and even children who are still in the care of their parents in their own homes, okay, we talk about the rights of children. Okay? And as you will notice later on, okay, while this presentation is entitled Custody of Children, the more appropriate subtitle would be I will present a rights-based approach to the custody of children, and we will see why. Okay, but before we go into that, those series of slides, I'd like to devote some time to these four general classification of rights of the child. Okay. These are the survival rights, protective rights, developmental, and participatory rights of children. And these four general classifications of rights are embodied in the international instrument to which the Philippines is a state party, the United Nations Convention on the Rights of the Child. Okay. And in the heart of this international instrument that is now part of the law of the land in the Philippines is the concept, the basic concept of the child as a holder of rights. Why is this important? Prior to the United Nations Convention on the Child, okay, and when I say we in the legal community, we in the international legal community have always perceived children as being beneficiaries of the goodness or beneficence of adults. When the UN Convention on the Rights of the Child was instituted and was adopted, and it still remains as the most widely acceded to international treaty in the world. It introduced the revolutionary concept of the child as a holder of rights. Okay, when we talk about rights in general, there is no right when there is no person against whom that right may be demanded against. Okay? And therefore, when we talk about children's rights may be demanded against anyone, not just third persons, meaning children, people who have no relation to children, but even against the parents of the child. Okay? This principle or this revolutionary concept of the child being a holder of rights is enfleshed or given life in our system of laws. The principle of parens patriae is not just embedded, it's institutionalized, it is enshrined in the 1987 Constitution of the Philippines, where the primary responsibility of parents is only called primary, okay? Because if and when the parents fail, or if and when they themselves violate the rights of children, then the principle of parens patriae kicks in to secure all the rights of children. When we say all, we talk about the four general classes: survival, protection, participatory, and developmental rights of the child. And so we will see not just a legal framework or a system of laws, but a social framework as well. Okay? And the next level of protection is provided in the foster care and alternative parental care instituted by law and by the Philippine Constitution. And when that is insufficient or that has served its purpose, there is a bigger sieve or a bigger security net, if you will call it that, where everyone is declared parents of the state, not just the government structure, but even the non-government structure, all pertaining to the protection of the rights of children. Okay? In the previous slide, we saw that the parents have a primary responsibility. In this slide, we will see that the primary, and overriding consideration, meaning it trumps or it defeats or it will defeat any and all challenge to the best interest and welfare of the child. And we will be repeating this principle, best interest and welfare of the child, throughout the discussions on the custody of children. And when we say overriding consideration, it will override parental authority. It will override government administrative or executive action. And it will even override the adjudication of lower courts, as when the Supreme Court, as the primary and principal interpreter of what the Constitution provides and mandates, what the constitutional principle of parens patriae dictates. The Supreme Court will tell us that parental rights, government executive or administrative action, or even actions of lower courts or family courts will be subservient to the primary and overriding consideration as the best interest and welfare of the child. When we talk about custody of children, we consider the best interest of the child. And in relation to parents, that custody may be given up in the process that we call voluntary commitment. Custody of children may also be disturbed, okay, by government, executive, or administrative action in the form of protective custody, sometimes also exercised by child caring and child placement agencies such as the Bantay Bata 163. And of course, when we talk about conflicting claims on the custody of children, we talk about the family courts taking in or stepping in to settle disputes on custody of children in court adjudication. Okay. When we talk about custody of minors, we talk about the Constitution and the laws of nature. So when we talk about custody of children, this is granted to the child's parents by nature. Okay? When children are born from their parents, okay, that is understood to mean a natural connection. Okay? But on top of that, the Constitution and the laws of the Philippines, okay, attaches the custody of children to the parents by law, by operation of law, and by force and effect of law. For what purposes? For the preservation and development of children, as well as their development of their intellect, the progress of their education, not just of their mind, but of their heart and their senses. Okay? And the concept of child custody springs from the exercise of parental authority. Okay, I spoke about, okay, the concept of children as having, okay, a revolutionary effect, okay, in the field of law. Why? Okay, because the original concept of parental authority derives its origins or its principles from Roman law. Or in Roman law, parental authority is called patria potestas. But now it has evolved, okay, to include, okay, in Roman law, okay, and this is ancient Roman law, women and children are not considered persons in the legal sense. So women and children under Roman law are chattel, are part and parcel of a man's property. And so we thank the developments in the field of international and local law that we have evolved from that archaic and Jurassic conception of children and women from being chattel to being and living holders of rights. And therefore, okay, fast forward to today, okay, we have, okay, a concept of the best interest and welfare of the child, okay, as being the primary and overriding consideration for all questions, for all legal proceedings involving children. Okay? As a general rule, when a man and a woman marries, they exercise joint parental authority over their children, over their child. Okay? When a man and a woman gives birth to a child, okay, but they have not married each other, then even under the old civil code, under the new, okay, family code, which is now the controlling law, the parental authority is given to the mother. Okay? General rule when couples are married, joint parental authority. When they are unmarried, parental authority resides in the mother. Okay? But what is included in, okay, so when we talk about the parental authority in the mother, okay, when parents are absent or when there is no guardian, and when we say guardian in the legal sense, these are persons appointed. So they have to their benefit a court order granting custody or parental authority or the exercise of some of the rights and mandates, authority of parents. Okay? But in the absence of parents and court-appointed guardians, parental authority is transferred by operation of law to the grandparents, the surviving grandparents. And these include maternal and paternal grandparents. Okay? And okay, in the absence of grandparents, the child's oldest brother or oldest sister who are over 21 years of age, unless they are unfit or disqualified, or if they have a physical or mental disability or disorder that renders them unfit or unqualified to exercise parental authority. In the absence of the parents, in the absence of the surviving grandparents, or incapacity of the surviving grandparents, absence or incapacity of the oldest brother or sister, the child's actual custodian, where the child is found, in whose care the child is found, then they will be protected by the law as exercising substitute, meaning substituting to the parents in legal guardians in the exercise of parental authority over children. Okay? Please keep in mind, okay, in unmarried couples, the mother exercise sole parental authority. Okay? And these are the only exceptions. And the law calls them compelling reasons for a mother to lose custody. And you will also note in the context of married couples, okay, either the father or the mother or both of them will also lose custody of their children in the following instances. Okay? When they go insane, when they're guilty of neglect, abandonment, okay? The law and jurisprudence speaks of immorality and unemployment, okay? Habitual drunkenness, drug addiction, maltreatment of the child. We will discuss this later on in the context of child abuse laws. Okay, an affliction with communicable illness. Now, okay, in the context or in the real context of a post-pandemic world of COVID-19, this exception in number 8 is very relevant. Okay, however, okay, the affliction of a communicable illness such as COVID-19, okay, it is not a permanent condition, and therefore, while during a person's, and not just the mother's, during a father or a mother's affliction with COVID-19, while parental authority or custody of children may be suspended, okay, for what purpose? To secure the survival and normal development of the child, okay, it must be restored when the conditions or the affliction of a communicable disease has already lapsed or transpired or is no longer threatening the health and life of the child. Okay? And so when we talk about parental authority, while it proceeds from the Roman law concept of patria potestas, okay, under modern law and under the Philippine legal framework, parental authority is not, strictly speaking, in the legal sense, an authority. It is not a power. Strictly speaking, it is not even a complex of rights or a collection of rights. Okay? It is not sovereignty, as when the state exercises sovereignty above its citizens. Okay? The Supreme Court says parental authority is a task. It is a sum of duties. It is a sacred trust for the welfare of the minor. Okay? And a sacred trust that can be suspended, or it can be taken away if the exercise of the rights, power, and sovereignty over the children should become inconsistent with the purposes. And what are the purposes again? Okay, the physical preservation, the child's normal development, and the cultivation of their intellect and education of their heart and senses. See, embedded in these purposes are the inherent and natural rights of children to survival, to protection, to their normal development, and to their rights to participate in all proceedings affecting their welfare and development. Okay? While in Presidential Decree 603, Civil Code, and the Family Code, we will read about the right to custody. And again, when the couples are married, joint custody, joint parental authority, and unmarried, only the mother, okay, is allowed to exercise these rights. And as you will see, the list of what is included in parental authority only talks about two specific rights: right to keep the children in their custody and right to discipline. I put an asterisk there because that should be understood in the context of present and stricter anti-child abuse laws. Okay, you cannot talk about discipline using corporal punishment. That is expressly prohibited by law, or RA 7610. The next few items under parental authority, okay, of course, when we talk about these are the exact words from the Civil Code, Family Code, and Child and Youth Welfare Code, but okay, it is inclusive of the rights of women or girl children as well. So to give children affection, companionship, and understanding, to extend to him the benefits of moral guidance, self-discipline, and religious instruction, supervise activities including recreation, inculcate the value of industry, thrift, and self-reliance, civic duty, duties of a citizen of this country, commitment to the country where he or she was born, to always set a good example. Okay? I wonder how many parents are capable of these, okay, duties, to provide, okay, adequate support. And when we say support, these are everything indispensable for living: food, clothing, shelter, medical attendance, especially in the time of COVID-19, educational support, including transportation, okay, to and from school. Now, everyone is studying from home. Okay. So what support will include? Internet connectivity to be able to study. And okay, this may also be an authority to administer the property of the child according to his best interest, keeping in mind the parents, or in the case when only the mother exercises parental authority, they only have the limited authority to administer. They cannot sell or they cannot do acts of ownership. They can only do acts of administration. Only acts that are necessary for the preservation of the property, and therefore they cannot use or alienate, sell, or transfer property, assign property to the detriment of the interest of their children. Okay. When we talk about custody of children, okay, when we talk about the different interactions between the rights of children, the authority of parents, and of course, the legal and constitutional mandate of the state and government, we talk about voluntary commitment by the parents and involuntary commitment as initiated by the state. But in both instances where the parents voluntarily give up custody of their children, and when it is necessary for the state agents or agents licensed and accredited by the state are exercising acts of either temporary protective custody, or placing children in alternative parental care or foster care, or in public and private institutions, public and private orphanages, or in cases where there is a possibility, okay, that the best interest and welfare of the child will be served by either placement of the child with next of kin or relative adoption, okay, or not next of kin placement, okay, domestic adoption in the Philippines, and in extreme cases where there are no available next of kin, no available and willing next of kin, and no available local families willing to adopt the child, then the involuntary commitment of children may also lead to inter-country adoption. But again, going back to the central overriding and primary consideration of what is in the best interest and welfare of the child. Okay. So when we talk about involuntary commitment of children, we talk about this particular Supreme Court rule on involuntary commitment of minors. Again, the exhortation of the purposes to promote the child's best interest and welfare, and to enhance opportunities for a useful life, whether it be with the relatives of the child or with non-relatives of the child in the Philippines or outside of the Philippines. We will see these relatively familiar conditions of neglect, abuse, cruelty, exploitation, and other conditions that violate or impinge or impair the rights of children, resulting to the negative effects to a child's development. Therefore, the state will intervene, will step in to promote the best interest and welfare of the child, even against the consent and even over and above the objection of the parents. Okay. When we talk about involuntary commitment of minors, we talk about dependent, abandoned, neglected, disabled, mentally retarded, physically handicapped, emotionally disturbed, and mentally ill. By the way, you do not have to take notes or take pictures of these slides because I will be sharing these slides. You may ask PWU for copies of these slides. So they are free. So you just need to go through these slides with me. And if you have any questions, you may ask them later on. Okay. When we talk about commitment, we talk about commitment of the custody of children. Okay? So commitment, legally speaking, is the juridical act or legal act of entrusting a child to the care of the department. When we talk about the Department of Social Welfare and Development, and all duly licensed and accredited child placement and child caring agencies all over the Philippines. These include both the public and private orphanages. Okay. Whom will entrust to the DSWD and the child placement and child caring agencies, the courts, the family courts, the parent or legal guardian, or any interested party. And interested party here may be the founders of a foundling, or as we earlier saw, the actual custodian of the child, or where the child may be found at the moment, or whoever is taking care of the child at the moment. Okay. We saw that the custody of children may be surrendered voluntarily by the parents to the DSWD, to a duly licensed CPA, Child Placement Agency, or CCA, Child Caring Agency, or an individual. We will see this later on. Okay. Where an individual will be a proper, okay, custodian of the child. Okay, who will entrust or surrender the child? The family court, in a proceeding called involuntary commitment of the child by the parent through a deed of voluntary commitment, by a guardian, okay, same, through a voluntary commitment, okay, or any interested party, as in the case of founders of foundlings. Okay. Who is an involuntarily committed child? An involuntary committed child is one whose parents have been permanently and judicially deprived of parental authority. Remember the picture of the three sieves? Okay, when state authorities, in particular the family courts or the family court judges, they judicially determine, meaning after notice and hearing in an involuntary commitment proceeding, okay, finds the following cases or the following causes, the following legal causes of abandonment, okay, substantial, continuous, or repeated neglect, as in the case of children in the streets or children in conflict with the law. Okay. In cases of child abuse, where the parents, they themselves commit the child abuse, or in cases of incompetence by a physical or mental disability or condition, where the parents are unable to discharge their parental responsibilities as enumerated in the list earlier under parental authority. A voluntary committed child, as earlier mentioned, whose parents or legal guardians have executed an affidavit called a deed of voluntary commitment. By the way, a deed of voluntary commitment may only be given, may only be knowingly and willingly relinquished to the DSWD, to a public or private child placement or child caring agency, or an individual authorized by the department. Okay? Any parent, a mother or a father, or mothers and fathers, cannot voluntarily commit a child to a person of their choice. Okay? It has to pass through a rigid and strict scrutiny of the courts, of the family courts, before, okay, the strong legal bond of parental authority may be severed or cut, and in certain cases, severed and cut so that it may be reattached to a permanent family in the case of local or intercountry adoption. Okay. In the next few slides, we will see the definition of children who may be involuntary commitment. And when we say involuntarily committed, this will be independent of the will of the parents. Okay. When state authorities have determined that it is in the best interest of a dependent child, of an abandoned child, or of an abused child, okay, to be committed or transferred to the care of public and private institutions, or even private persons in the case of local and intercountry adoption, okay, then these definitions will control. Because a dependent child is one who is without a parent or guardian or custodian. Okay? That means nobody's taking care of the child. Okay? Or whose parents, guardians, and custodians for good cause desires to be relieved of his care and custody. Okay? Only for good cause. And when we say for good cause, these are causes, only causes authorized by law. Okay? The parent cannot by whim or by will just abandon children. In fact, we have laws, we have criminal laws that punish parents who abandon their children, and the result of such abandonment endangers the health, the life, and the limb of the child. Okay? There are legal consequences for criminal neglect or criminal abandonment. And as a result, a dependent child becomes dependent on the public, on the state. Okay? Under the principle of parens patriae, the state will intervene to secure and give all the rights. And when we say all the rights, survival, protective, participatory, and developmental rights of the child. The next definition is the definition of an abandoned child. Okay? An abandoned child has no, or because sometimes an abandoned child has parents, but they do not care for the child. No proper parental care or no proper guardianship. Or whose parents or guardians have deserted him for a period of at least 3 months, previously under Presidential Decree number 603 or the Child and Youth Welfare Code. This period is 6 months. But because of the best interest and welfare of the child, later legislative enactments have shortened this period so that the child will not need to wait for unwilling or unable parents to step up and become proper parents or parents providing proper parental care and guardianship. Okay? This is the evolution of the term legal abandonment. Previously, under this, okay, Child and Youth Welfare Code or PD 603, the Supreme Court ruled on commitment of children under the 2009 law of RA 9523. It is now down to 3 continuous months when we say abandonment of children. Okay. Now go to the neglected child. Okay. The conditions of the pandemic, COVID-19 pandemic, has, okay, not just exerted strains or pressures on government resources. It has also resulted in strains, in pressures on individual families, and has therefore spawned an unprecedented wave of families who are unable to provide for the basic needs, of children. And this is on top of those families or parents who deliberately, neglect the needs of their children. And when we say neglect, we do not only, or the law does not only contemplate total abandonment or neglect of the needs of the child. It may also be inadequate attention, inadequate provision of physical or emotional support from the parents or guardians. Okay? And these are conditions that we reasonably expect in a crisis of global proportions, such as the COVID-19 pandemic, which is not only felt in the Philippines, but all over the world. Okay? The involuntary commitment of minors also contemplates involuntary commitment of disabled children. And these are the different categories. Okay? And there is also a catch-all phrase, those with similar afflictions of being mentally retarded or having global developmental delay, physically, emotionally, mentally, and those with cerebral palsy. These are specific conditions of the mind or psychological makeup of the child. When we talk about the second or the first mentally retarded, we have subcategories of mentally retarded children. Okay. You need not go into each and every one of these. Okay. You will get these slides anyway, so you just go through them in your own leisure. Physically handicapped, does not only contemplate crippled, deaf, mute, or blind. It covers all other defects or conditions that restrict the means of action or communication with others. That's the definition, the legal definition of a physically handicapped child. The law also provides for a definition of an emotionally disturbed child, not afflicted with insanity or mental defect, but they are unable, these children are unable to maintain social relations because of emotional problems or emotional or psychological complexes. Okay, mentally ill, behavioral disorder, functional or organic, but it has to be of such degree of severity as to require professional help or hospitalization. So you can imagine in the involuntary commitment of mentally ill children, legal experts, experts in the field of psychology, behavioral, child psychology, child behavioral sciences will necessarily be presented or will necessarily have to testify as expert witness. Okay? So when we talk about legal proceedings, we're not talking only about the petition for the involuntary commitment of a child. We're also talking, for example, for parents who are or whose children have been rescued by the DSWD or child caring agencies such as then Bantay Bata 163. They were temporarily deprived of their parental authority. They may also file a petition for the restoration of parental authority after involuntary commitment of children, prior to final severance of a parental authority and prior to the finality of a petition for adoption, because when a petition for adoption case has been declared final and executory, then the biological parents may no longer, as a general rule, may no longer reopen, because in a petition for adoption, presumably the best interest and welfare of the child has been threshed out, considered, and passed upon by the court, and therefore that final decree of adoption will not be disturbed, still to promote the best interest and welfare of the child. In cases where the parents voluntarily, willingly commit the child to an institution or an individual authorized by law, the DSWD, and such institution, for example, fail, or in extreme cases, the house parents or other officials of that institution or that individual, they themselves commit child abuse, then the concerned parents or the concerned individuals may petition for the removal of the custody of those children or the restoration of the parental authority back to the original parents, whether biological or legitimate parents. There is also a petition for the commitment of a disabled child, as well as the discharge of that judicially committed disabled child. Here, when a minor is entrusted to the family court, or when the minor, in the legal sense, is in custodia legis, or within the authority of the court, any action, whether to put the child in an institution, to return the child to the parents, or to entrust the child to a child carrier or placement agency, everything will be submitted to the discretion of the court. Okay? And while we're talking only of the petition for involuntary commitment of children, we may also be familiar with these other proceedings, such as, sorry, it's not here, like, I think it's in a later slide, like petitions for habeas corpus, But in a petition for the involuntary commitment of the child, these are the following authorized persons, keeping in mind the conditions, and the conditions are found in the definition of the abandoned, neglected, abused, the physical, mentally handicapped child, the secretary or the secretary's authorized representative, the DSWD regional or field office director, or the executive director of a private licensed and accredited child placement agency or child caring agency may petition the court. Any one of these persons are legally authorized to file an involuntary commitment of minor's case in a family court. And where do they file? In the place where the parent or guardian resides, or where the child is currently found, the actual physical location of the child. Because family courts, just like regional trial courts, have defined territorial jurisdictions, and therefore they may only take cognizance of cases or persons or matters within the territorial bounds of their province or city. So these are the contents of the petition. The names of the parents or guardian and their place of residence, the legal causes or the fact showing that the child is indeed dependent, abandoned, or neglected, who is the actual custodian of the child, because that will be the person to whom the court order will be addressed, because the final disposition of the court will be to place the child to the care or the custody or to the parental authority to whom the child will be permanently or temporarily committed after all the proceedings have been done. And what are these proceedings? It starts with the service of summons okay, to the following persons. And it includes a summons, the copy of the petition, and the notice of hearing to the parents or guardians and the public prosecutor, not less than 5 days before the hearing. Okay. If both parents of the child are dead, and neither parent can be found in the province, okay, the child has no legal guardians residing in the place, the family court judge may appoint a guardian ad litem, or a guardian, a legal guardian for the duration of the litigation. That is what a guardian ad litem means, for the limited purpose of the proceedings. A guardian ad litem. Okay. And these are the conditions where a guardian ad litem can be appointed, as when the parents or guardians of the child cannot be located, or summons have been sent to the last known addresses, but they fail to appear. They receive the summons, but they fail to appear. Or even if, in the third case, they appeared before the court, but in the assessment of the court, they are incompetent to protect the best interest and welfare of the child. As when, in certain cases that we've handled, the parents themselves are guilty of trafficking their own children or selling their children to other people. Okay. What are the qualifications of a guardian ad litem? You may want to take note of these, because most of you, okay, will fall under 2 or 3. Okay. And also, okay, now that you are hearing all of these legal proceedings, you now have a background and familiarity on the judicial process of commitment. So you may also serve, okay, as having, okay, as students and advocates of social work in the Philippines. You are familiar with social service programs and the different stages of child development and the different needs of the child throughout the phases of child development. And of course, the people who made these or who drafted these rules must be lawyers, because they included themselves in the list in number 4. Okay. The duties of the social worker, okay, in a case for involuntary commitment of minors, okay, the Supreme Court rule on involuntary commitment of minors only tell us that the social worker is authorized or is responsible for preparing the case study report and evaluating the propriety of the child's commitment and making the recommendation, making the all-important recommendation. 99.99999% of the time, whatever the social worker recommends goes with the family court judge. That is how important the role of the social worker. Okay? And while this rule may reflect only the responsibilities of the social worker in a legal proceeding such as involuntary commitment of minors, the real work or the real responsibility of the social worker entails much more than that. Okay, sometimes the preparation of the case study reports, okay, will tell you that the social worker does more than that, because the social worker must be able to handle not just the case of the child before the court, but to treat the child's needs in its entirety. And that is more than, I believe that encompasses even beyond what the parents are willing and capable of doing, because the social worker must be able to take a step back and look at the totality of the child's condition to be able to make this very important recommendation, which underlies and underpins the best interest and welfare of the child. Okay? Sometimes, okay, over and above the objection of the parents, the biological or legitimate parents, and sometimes even against the determinations of the government authorities. So you will see a lot of social worker heroes standing up for the rights of the child, okay, against the world. And I've seen this in one too many cases, okay, for me to be able to say that I myself, okay, am a witness to the great work that social workers do in our society, okay, not just in protecting the rights of children, okay, but also in, okay, making sure that all the different institutions of Philippine society are re-engineered to be able to respond to the different rights. And when we say different rights, we say survival, we say protection, we say developmental and participatory rights of the child. Okay? The social case study report of the social worker just talks about the finer points to be considered by the court. But the social worker does a lot more than that. The social workers, or upon the social worker's shoulders, rest the responsibility of making sure that this child, okay, after I have done my responsibility in the casework that is involved, I will be able to sleep at night knowing that this child is on track to his or her normal development, taking into consideration all the history of the child. And sometimes that history entails history of abuse, history of neglect and abandonment. How do I restore the child's normal development? And that is a tall order for any person. Okay. Okay. Contents of the social case study, the report, comprehensive in its scope and in details. The duty of the public prosecutor, again, to look into the legal causes. And if there are competent proof of these causes, and that these proof and evidence, pieces of evidence, are presented in court. Okay? Rarely does this happen, that a child's needs would require his or her own counsel. But in keeping with the child's right to participate and participate in a meaningful manner, the Supreme Court rule on involuntary commitment inserts and institutionalizes the child's right to be heard by counsel, not just of himself and of the parents or the guardians, but the assistance of counsel is guaranteed by the law. On the date of the hearing, okay, the child carrying agency, the child placement agency will bring the child to court. Okay. Now this changes in the time of the pandemic, okay, when the overriding and primary consideration of the child's health and life overrides these rules. Okay. Sometimes it is enough for the child to be in a Zoom hearing. Okay. Zoom hearings are now allowed. Okay. So that this rule, while it mandates bringing the child into court, okay, now it has been relaxed to include, to protect the child's life and the child's health, and of course the social workers and the officials of the institutions, both public and private, okay, then they will be allowed to use technology because it will serve the same purpose. The family courts, okay, will dig into the causes. Are there enough evidence to prove the dependent, abandoned, and neglected status of the child? And why these conditions happen, okay? The cause and circumstances. And of course, if these circumstances of being dependent, abandoned, and neglected are proved, then the family court will render judgment, okay? And sometimes will issue provisional orders of visitation and inspection to ensure that during the pendency of the hearing of the involuntary commitment of minors, the best interest and welfare of the child will be protected. As when, for example, there are reports of abuse even in institutions, even under the care of the persons entrusted by the court to temporarily take care of the child, then it will be the court will give orders either to take back the child, bring the child to another institution, and okay, sometimes these will result in the not just changing of the custodial arrangement of the child, but also penal or penalties, order of removal of commitment of the child to another CCA, but order of suspension and revocation of the license of the agency of the individual was originally given the authority to have custody over the minor child. Previous to this rule of the Supreme Court, only the DSWD in the exercise of its administrative and disciplinary authority over all public and private orphanages may issue orders of suspension and revocation of the license and accreditation of private orphanages. However, if these matters are brought before the court may directly order a suspension. When an order of suspension or revocation of a license of an agency that effectively closes the operations of an orphanage. So that is equivalent to a death sentence for a child caring institution or child placement institution. And those penal sanctions are only handed down in extreme cases, as when there are proven cases of abuse in those child caring and child placement institutions. Oh, this is the list that I was talking. These are corollary or related legal proceedings. For example, if the DSWD has rescued, or the Bantay Bata has rescued the child in a family where there is a situation of abuse, the parents may file a petition for the writ of habeas corpus to question that exercise of protective custody. Or even, for example, in conflicting claims between husband and wife, those who are legally, spouses who are legally married, who should have the proper care and custody of children. In both cases where the couple or the spouses are married, and even when the spouse or where the parties are not married, as when parental authority is granted to the mother, but because of compelling reasons, the father may contest. And this is the illegitimate father. The father may contest through a writ of habeas corpus, because the father is ready to prove compelling reasons to deprive the mother of the custody of children. Technically, the proper remedy is petition for habeas corpus, but sometimes they denominate it as the petition for the issuance of a writ of amparo, which is an equivalent legal proceeding to enforce the implementation of constitutional rights. The writ of habeas corpus is one such example of a constitutional right. Okay. Again, when we talk about the proceedings on child custody, we're not just talking about private rights of husband and wife, private rights of fathers or mothers. We're talking about constitutional rights of children to special protection, because that is the language of the Constitution. The state shall provide special protection of children, okay, over and above and overriding the parental authority of parents, okay, over and above the exercise of executive and administrative authorities of temporary protective custody. Exercise of temporary protective custody that is clearly spelled out in RA 7610. You do not need to go to court. The DSWD, the barangay councils for the protection of children, all licensed and accredited NGOs, non-governmental organizations, child protection, child placement agencies, child caring agencies, private child protection agencies may exercise temporary protective custody. Okay. Under the principle of parens patriae, when the parents, when the relatives of the child fail, we as parents of the state intervene to secure the rights of the child, okay, whose rights, the child's rights, have been violated either by the parents or the present custodian of the child. And of course, we talk about the exercise of the DSWD's regulatory authority over the child placement and child caring agencies, and exercise of administrative disciplinary proceedings over the personnel of these child placement and child caring agencies. And of course, in appropriate cases and in extreme cases, civil and criminal proceedings may be brought against those violating the rights of the child. And we talk about these specific laws on affecting the rights of children in custodial arrangements, whether these are in the pre or post-pandemic situations. Okay, we talk about the Presidential Decree 603, the Child and Youth Welfare Code, okay, the Inter-Country Adoption Act in 1995, the later law of the Domestic Adoption Act, 8552, the Supreme Court rule, okay, which was promulgated by the Supreme Court in 2002, the CDCLA law. What is the CDCLA law? The certificate declaring the child legally available for adoption law. Remember the law that shortened the period of waiting time for abandoned children to 3 months. And now we see, okay, a new species of adoption in Philippine law. And this came at the heels, almost at the heels of the pandemic in 2019. Now we see the possibility of an administrative adoption of children. And we're here talking about de facto custody of children. Why de facto? Because when you simulate, and this is called the Simulated Birth Rectification Act, when actual custodians, because they are not legal parents, okay, because prior to RA 11222, only adoptions that go through the courts are recognized as legal adoptions. But now with RA 11222 under certain specific legal conditions and factual considerations. Now, a parent or an actual custodian who simulated the birth certificate may now file an administrative case in the local city or municipal social welfare and development office in the city or municipality where the actual custodian is residing, provided they are the ones named in the simulated birth certificate. They may now file an administrative case, and only an administrative case, for the adoption of their wards, of the children that they took care of and that they illegally, take note, illegally registered in their name. They just simulated. They made it appear that they are the parents in the PSA, Philippine Statistics Office, the NSO birth certificate. But that is illegal. That is falsification of public documents. That is trafficking of children. But RA 11222 provides now a general amnesty for all those who simulated the birth certificates of the children that they are caring for. But now, the law only provides for a window, a 10-year window, 2019 to 2029, for these parents or these custodians of children to rectify or legalize their adoption through an administrative. They don't need lawyers. They just need to fill up the forms and submit the required documents. It has now been made easy, taken out of judicial proceedings, and now within the power and authority of executive and administrative agencies such as the local city and municipal social welfare and development. It will be assessed, filed in the city and municipal social welfare and development office, submitted to the regional offices of the DSWD, and submitted to the final approval of the DSWD secretary. And the decision of the DSWD secretary, an executive, an administrative official, will become a final and legally binding order of adoption. Administrative adoptions are now recognized by RA 11222. And so I think we end with that. So we can now entertain your questions.
Thank you very much, Attorney Noel Del Prado, for that great and informative presentation. I think all of us learned a lot from your discussion regarding child custody cases, especially in this time of pandemic. Personally, I've learned that it's important to uplift or uphold the best interests of every child, especially in this time of pandemic that alam naman po natin na lahat tayo ay nagkakaroon ng problems, or it could be family problem. And I've learned that as parents, according to attorney, as parents of states, we all have responsibility in upholding the best interest of the child by helping or by working together to 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 help every child na nakikita natin or nalalaman natin na kailangan ng tulong. So how about you, Ate Mai? Can you share about your insights or learnings about
Yes. Siyempre ako din, yung regarding sa classification of the rights of the children, which is the survival, protective, participatory, and development rights. And also the duties of the social worker. So napaka-laki na duty natin Lalo-lalo na, syempre, sabi nga ni attorney is to protect the rights of the children. So yun yung ating big role. Kasi tayo yung authorized na prepare ng mga case study, evaluating the propriety of the child's commitment, and many more po. Thank you.
Okay, and now we will have an open forum, still with the help of Attorney Noel Del Prado, to answer questions about our topic today, which you can type in our chat box and in our Facebook and YouTube live chat, to be followed by a question and answer game for our participants. So come on, guys, send in your questions. Oh, we have questions here in our Google Meet. According to BSS student Anika Ligaralde, attorney, what are the challenges you have faced or encountered in handling child custody cases during this pandemic po?
Most of the difficulties are not legal. Most of the difficulties now involve physical restrictions. Number one, for example, the confusion in the different quarantine classifications. They present a real challenge. For example, even before the pandemic, for example, when there is a contest between husband and wife, it is always a challenge to find a common ground. For example, when husband and wife are married, if they are legal spouses to each other, then you always have to contend with satisfying joint parental authority as when they are still married to each other but are now maintaining separate homes, okay, for one reason or another, okay? And that is exacerbated by pandemic conditions. For example, if pre-pandemic, the husband and wife agreed, okay, during the week, 5 days a week, the child will be with the mother because presumably the child is studying, and during the weekends, the father may either visit or keep the child in his separate home. But now, how do you do that in this time of pandemic, okay, where it is highly discouraged to transfer from one household to another, okay, by danger of transmission, by danger of infecting people from one to the other, and in fact exposing the child to multiple sources of possible infection or contact with, because keeping in mind it's not just the two places of residence, it is also during the transit who will be bringing the child to and from the two different places. So these are issues, okay? And if before the pandemic, these types of arrangements are very hard for couples, can you imagine now, okay, with the additional cost, with the additional precautions, with the additional dangers being brought about by, and these are real dangers threatening the lives and health of not just children, but all the other members of each household. So in terms of legal proceedings, I think the lawyers have it good, okay, now, while some courts still hold physical face-to-face hearings, okay, most of the cases are now either canceled, okay, which also brings about the postponement and additional, because these cases will not go away just with the postponements. These are added onto the backlogs of cases. But in terms of the parties, okay, these will be, okay, not only translate into additional cost, but additional inconvenience. Okay, can you imagine taking a leave from work, okay, multiple times because of canceled hearings or even canceled meetings? Okay. I think there's another question here. 7 years old po ako at ayon po sa batas, nasa edad ko po ay dapat nasa poder ako ng aking nanay. Kailan po, anong sitwasyon ako pwedeng mapunta sa poder ng aking tatay? Yan, maganda yung tanong. Okay? The child preference rule is provided in a situation, strictly speaking, when the mother and father are married. But for some reason, they separate without the benefit of legal separation order or even annulment of cases. So in these cases, or in these instances, the child below 7 years old or before the 7th birthday of the child, the law declares that the child, okay, there is a legal presumption that the child chooses the mother. Okay? And this, the rationale behind this, okay, is supported by psychological studies that children of tender age or those below 7 years old need or are dependent on their mothers. Okay, not to say anything about fathers who are also caring, but the law, the legal presumption will favor the mother, okay, unless, now you're asking, anong sitwasyon po pwede mapunta sa poder ng tatay? There are compelling reasons, and I think one of the slides provide for that. And the clear reason, okay, that is always uncontested is that when in situations of abuse, as when the mother inflicts corporal punishment on the child. And now, as I mentioned earlier, in situations of child abuse, keeping in mind the definition of child abuse now includes not just physical harm, okay? It includes psychological harm, as when the third example of child abuse provides any act by words or deeds which demeans, degrades the intrinsic worth and dignity of the child by words or deeds. So if you say hurtful words to a child, that is child abuse. That is one compelling reason where the mother can be deprived of the custody of children. And that applies not only to the mother, that applies that applies also to mothers and fathers, even both parents who abuse their children. They can be deprived of legal custody. Their parental authority may be suspended, or the DSWD can intervene and exercise temporary protective custody to rescue the child in the situation of abuse. Child abuse definition also includes the unreasonable deprivation of the basic needs of the child. Yung mga batang pinapalayas, yung mga batang hindi pinapakain o pinaparusahan kaya hindi ka kakain, lalabas ka ng bahay. Okay? Can you imagine that happening in the time of pandemic? That is not only detrimental to the development, the psychological development of the child, that's exposing the child to the dangers outside of the home, exposure to COVID-19. Okay? And those are compelling reasons for not just the mother, but both the mother and the father to be deprived of their right to custody of their children. Okay, there's a good question from Raquel. Okay. Regarding RA 11222, beyond the window of 10 years administrative rectification, what would happen to the parents or guardians who are unable to file? Okay, number one, they will not enjoy the benefits of an administrative adoption. Okay, they will go to the pre-RA 11222 regime, where they may have to go to court. Okay, what happens or what happened before RA 11222? If, okay, in the situation being contemplated here is a person, not the biological parents of the child, simulates, inilagay nila sa pangalan nila yung bata. Sa birth certificate, halimbawa, nilagay ko ako, yung pangalan ko, at yung pangalan ng asawa ko, sa isang bata na hindi namin anak at hindi namin inadopt through the courts, not through legal adoption. Inalagaan lang namin, pineki namin yung birth certificate. Yan yung sitwasyon. Okay. Now, okay, after the lapse of 10 years or prior to RA 11222, I'd have to go to court to cancel that simulated birth certificate. I would have to, after the cancellation, because keeping in mind, if you want to rectify, if you want to legalize your adoption, first you have to cancel the original, the simulated birth. Why? Because legally you cannot adopt your own child, because that is your own child. So you have to cancel that in a legal proceeding. You have to hire a lawyer, go to court. Number two, you have to declare the child legally available for adoption. That has been declared as a legal, an administrative proceeding now. But after that, you will have to go to file another case for petition for adoption. So you have three legal proceedings: first judicial, second administrative, third judicial again. So two cases where you will require the services of a lawyer. Okay? Whereas now you're being given a window. Of course, 2 years have already passed. You now have 8 years to rectify the birth certificate. All three will now be administrative. You now need to file local social worker, filed with the regional offices of the DSWD, and decided finally by the Secretary of DSWD. No courts, no lawyer needed. Okay, what more incentive do you need, okay, for that?
Okay, thank you po, Attorney. We have another question po. What if the parents are still married, but the mother has another partner, but the mother are still living with the real husband? What should the child can do if she is affected of what's happening to the situation?
Okay, still married, mother has another partner. Keeping in mind, one of the compelling reasons is included yung it should not be immorality, that this situation may fall under that. Okay, so but the real reason is not because the mother is cohabiting with another person. The real reason may be the abandonment of the mother. Okay, I'd like to connect this with the previous question. Paano po kung yung asawang babae ang nang iwan? Ganun, di ba? Nang iwan sa kanyang anak sa ama. Sa ama po ba ito agad mapupunta? Okay, we have to distinguish. In that case, okay, let me discuss that first because that is related here in the second question. Itong question na what if the parents are still married but the mother has another partner, the mother still living with a real husband. Okay, first, kung kasal sila, okay, when the mother abandons the child, automatically the child goes to the father. Because whereas before joint parental custody, when the mother leaves the house, then kumbaga, she defaults. But, okay, we have to look further because sometimes the reason for leaving the house is the husband. So if the reason of the wife is because she is abused by the husband, then her leaving the house should not be interpreted as abandoning the child or even abandoning her parental authority. Okay? Because if the husband is abusing the wife, that may be a reason for the wife, okay, a legal justification, not just for the wife to leave the house and maintain a separate house, it may also give rise to the wife, okay, taking sole custody of the child, okay, based on the abusive nature of the husband. Of course, all of these are based on evidence. It cannot be just on a mere allegation. It cannot be just an accusation. You have to prove what you allege. Okay. In the same way, in the question, okay, where okay, let me go back. It is different in a situation when the spouses are not married. Okay. When the spouses are not married, keeping in mind the mother has the parental authority. Okay. Family code provides when the mother is absent, parental authority of an illegitimate child goes to the maternal grandparents, sa lolo't lola, nanay at tatay ng nanay. Okay? And kung wala yung grandparents, kung merong adult na kapatid yung bata, doon mapupunta. Okay? Bakit hindi si tatay? Kasi si tatay, hindi naman legitimate father. However, that doesn't mean that the illegitimate father totally loses all contact with the child, because keeping in mind the best interest and welfare of the child requires that there is still contact with the father, that the child still recognizes he or she has a still mother or father. There is still benefit to the child even if the father is an illegitimate father, and therefore the father will not be deprived of visitation rights, not custodial rights, because the custodial rights is granted by law to the mother, in the absence of the mother to the grandparents, in the absence of the grandparents to adult siblings of the child. Okay, but again, in certain cases where the best interest and welfare of the child, and if the father can prove that it is in the best interest and welfare of the child that the child's custody be given to the father, then the court may decide in his favor. So I hope I've answered both questions that are related. Okay.
Thank you very much, Attorney Noel. So also to the participants, thank you for sending your questions, and we hope that it helped you to have additional knowledge. And to keep our program on a high note, let us have an online game. All you have to do is to answer the given question regarding our topic using the comment section in our Facebook Live. And the first participant who will get the correct answer for each question will have 100 peso GCash as a prize. So, paunahan sa pag-type, guys. So, okay, are you ready? So, partner.
I think, Ate Mai, they are already ready. The first question, according to the presentation of Attorney Noel Del Prado, you can type your answer on the comment section in our Facebook and YouTube live chat. So, according to UNICEF, how many abandoned children as of 2019? Again, according to UNICEF, how many abandoned children as of 2019? Go guys, you can type your
guys
in our Facebook and YouTube live chat. Mukhang thinking mode pa po sila, Ate Mai.
Sige, makikita natin. Okay guys, pabilisan ng type. Okay. Meron. From Raquel Bago, 153 million. Is that correct?
According to Attorney Noel, it is correct daw po, 153 million.
Yon, congratulations, Miss Raquel.
According to UNICEF yan, not according to me.
According to UNICEF.
Oh,
Okay.
attorney, according to UNICEF daw po.
Thank
So,
you.
for our second question, Ate Mai,
Yes. Who is considered the holder of rights? I think nasa first part yan nung sa discussion ni Attorney Noel. Who is considered the holder of rights? Go, go! Ezzy, pwedeng may choices.
identification ata to Ate Mai. Pero I think we
I think alam nila.
have a winner sa Facebook po.
Okay.
Ma'am Patricia, I'm sorry, Ma'am May. Correct answer po is child or children.
Okay. Congratulations.
So, may I respond to the last two questions in the chat box? Sayang naman.
Okay po, attorney.
Some people can benefit. But if the participants still have questions after this, you may send your questions to endelprado@gmail.com and I would be happy to answer them. I cannot promise that I will answer them promptly, but I promise to answer them eventually. So I hope you do not send urgent questions because I may not be able to. And you may also find me on Facebook, Attorney Noel Del Prado. So you may also send your questions there. I will be able to answer. The question here, what can you advise if yung bata po nakatira sa bahay ng lola sa father side, so paternal grandmother, and mother po napapadala lang ng pera at yung father po is minsan lang umuwi para dalawin yung anak? It will depend on what you want to achieve. For example, here, the child is being taken care of not by the parents, but by the grandparents. Okay? At least the mother is sending some sort of support. The father is absent and occasionally visits. Okay? If the child will be better off, for example, being taken care of by another family, for example, a family of a cousin. Most of the time in Filipino extended families, a family with a mother or father assumes the parental responsibility for a relative's child, where that relative is unable to provide a wholesome, incomplete family, a father and a mother figure. It's always advisable for the child to have a father or mother figure, even if that mother or father figure is a grandfather and a grandmother. And there is always stability. And I think the social workers would know more what the child needs in terms of the different stages of the child's developmental milestone, what the child needs in terms of support from outside, not just material support but also psychological support. The second question, if an adopted child have concurrent conflict with the legitimate child of her adoptive parents, and so the minor wanted custody to be transferred to her uncle. Okay, sometimes the solution is temporary vacation, and this is not provided in legal provisions. But sometimes you need, or sorry, all of the time you need to address the underlying cause of the conflict between an adopted child and a legitimate child. So what is causing this friction between the adopted and legitimate child? And most of the time, the answer is not just intervention with the adopted or the legitimate child. Sometimes a family conference, a family intervention, a holistic approach to the problem. Because sometimes certain attitudes, certain behaviors are being tolerated by the parents, while it may not be the active cause of the conflict. It is sufficient to make these conflicting behaviors thrive, and if left unanswered or unchecked, it will really escalate to bigger problems. And therefore, sometimes the absence of a moral authority in the home, or a um, cohesive or unifying authority, and sometimes it's not exercise of authority, but really um, giving the children access to some to a person who will listen, because sometimes children act up, not in all cases, act up because they are unable, or they do not see the adults as acknowledging their presence, acknowledging their needs, and therefore they act up in so many different destructive ways sometimes. And so therefore, uh, sometimes the problem with children is a symptom only of the parents' incapacity to properly provide parental care and guidance to their children. So we may not be looking at the right source of the problem. It may be with the parents, or even in the entire family dynamics, not to always blame the parents. So for other questions, endelprado@gmail.com. So I hope uh, some of these information may prove helpful to your needs.
Again, thank you po, Attorney Del Prado, for answering those questions. So, also, congratulations to all our winners. To claim your prizes, please comment your Facebook Messenger name so we can message you right after our program. Moving on, our webinar will not have been possible, of course, without the time and effort extended by our resource speaker and participants. With that, I would like to call Ms. Cecilia Cabile, Professor on Seminar on Current Trends in Social Work Practice, to award the Certificate of Appreciation to our resource speaker today, Attorney Noel Del Prado, and the Certificate of Participation for all our participants.
Okay, thank you, Essie. Thank you. This is an honor to present our Certificate of Appreciation to our distinguished and knowledgeable speaker, for today's webinar. Please allow me to read the content of the Certificate of Appreciation. Philippine Women's University, Philippine School of Social Work, Seminar on Current Trends in Social Work Practice, Class, Manila, Philippines. This Certificate of Appreciation is awarded to Attorney Noel Del Prado for imparting his valuable time and knowledge as a resource person during the webinar entitled Child Custody Amidst COVID-19 Pandemic on the 9th of October 2021. Signed by yours truly, Cecilia C. Cabile, RSWMCP, Professor of Philippine School of Social Work, and Ms. Evelyn B. Valencia, RSW, MSSW, Dean of Philippine School of Social Work. Attorney Del Prado, you are a great speaker. Again, thank you so much, for the time, that you've given us. We will send you your certificate after this webinar through email. Hope we can still have you, for the next or the other webinars. Thank you so much.
Thank you as well for having me. Always a pleasure to work with you.
Thank you. For our participants, we will also be giving certificate of participation. Again, allow me to read the content of the certificate of participation. So Philippine Women's University, Philippine School of Social Work, Seminar on Current Trends in Social Work Practice Class, Manila, Philippines. This certificate of participation is awarded to Anika Kayla Ligaralde for actively participating during the webinar entitled child custody amidst COVID-19 pandemic on the 9th of October 2021, signed by yours truly, Cecilia Castillo Cabile, RSW, MCD, Professor of Philippine School of Social Work, and Miss Evelyn B. Valencia, RSW, MSSW, Dean of Philippine School of Social Work. So this certificate of participation will be given to those who attended and gave their evaluation form. Again, to all those who participated, thank you so much. A big thanks, to all of you for sharing your time. Thank you for your support. Salamat. Salamat po talaga. Essie?
Thank you so much, Mrs. Cabile. So for our evaluation form, we will flash the link on the screen and in our Facebook and YouTube live chat. In filling out the evaluation form, make sure that you will put your valid email address and complete name. After doing so, an e-certificate will be sent in your email.
Okay, indeed, we had a very informative and productive time today. However, just like they say, everything has its ending. To conclude our program, I call on Ms. Ezinaya Umpok for her closing remarks, to be followed by a closing prayer and PWU hymn.
Again, good afternoon to all our participants today. We, together with my ever hardworking partner, Ms. Maylene Balderas, and the Philippine School of Social Work, want to express our deepest gratitude to Attorney Noel Del Prado for his time and dedication to share his expertise and knowledge on this field. Thank you so much, Attorney Noel Del Prado, and we hope to see you soon. Also, we would like to thank the very supportive Dean and Program Chair of the Philippine School of Social Work, Ms. Evelyn Valencia, for allowing us to have this kind of webinar. And to our professor, Ms. Cecilia Cabile, thank you so much, ma'am, for you have given us the opportunity to organize and explore new ways to cope and learn amidst this pandemic. Your guidance helped us make all this possible. We also want to thank Ms. Maricel Condino, Ms. Gina Manabat, PWICT Marketing Media Center team, and our classmates for helping us throughout this webinar preparation. And to everyone who joined and shared their time today with us, we thank you for being part of this activity. Your presence is greatly appreciated. May this topic help us to appreciate and eventually apply in our chosen fields. We hope that in one way or another, you have learned something that you can apply in your life or reach out to people who need it by sharing your knowledge to them. This may be a trying time for all of us because of the uncertainty brought by the COVID-19 pandemic, but this should never stop us from learning and striving to fulfill the things that we want, especially in spreading knowledge and positivity to everyone around us. May we never lose hope during this time, rather be the source of light to whoever needs it. See you on the next webinar series, which will be conducted tomorrow and next Saturday. Again, thank you so much and have a good day ahead. Stay safe, everyone. Now, let us put ourselves in the presence of the Lord for a closing prayer by Ms. Maylene Balderas.
Okay, all together in the name of the Father, the Son, the Holy Spirit, amen. Graciously, Father, thank you for being with us throughout this webinar and making this day a successful one. Thank you for all the graces and blessings you have given to us. Thank you for giving us time to acquire different knowledge from our guest speaker. Help us to carry these new learnings and experiences in our mind and put them into action. As we go from here, make us fruitful in the work you have given us to do. Amen. In the name of the Father, the Son, the Holy Spirit. Amen.
And that concludes our first webinar series. To officially end our program, join us in singing the PWU hymn. Again, I'm Ezinaya Umpok.
And I'm Maylene Balderas, your host today, now signing off.
Thank you so much for sharing your time with us.
Stay safe and mabuhay po tayong lahat.